So,
I mean, how do we get so entangled with
Correct.
You should speak at the next time I Federal Reserve does a Fed, everyone to speak at one. Because it all, this is brilliant.
What's that initial pleading you have on the phone?
Is there any jubilee plans for us or anything like that outside of the structure?
not in their plan.
But in our plan.
Well, okay, but that's a good point. Phyllis just said, how do we get entangled? You know, as I've said to you guys several times, I can put this into a 4-hour presentation, a whole day, 2 days, whatever. It goes so deep.
It does.
You were supposed to
that
come up
it will
to
blow your mind.
Sacramento
Does
for
this
3 days and
connect
then
to the Masons and the bloodline?
Absolutely,
Yeah.
absolutely, absolutely. But here's the bottom line. Everything, let's take definition, contract, sovereign. What's the definition? If you're sovereign, that means no authority is above you.
Right.
It means the only way you can interact with someone else is by contract, okay? All of this works because the sovereignty was given to, yes, the free white males, but we can correct that and include everybody else. Bottom line is the people have sovereignty, but a sovereign has the capacity to contract in any way. And if we contract out of our sovereignty into accepting civil rights, and we are looked upon as having presumed to have accepted it. Is there fraud involved in that?
Absolutely.
Is what we're doing here in the Republic establishing the grounding point for severing that consent, because fraud has no statute of limitation, and all that needs to be done is it has to be timely challenged. Okay, just as jurisdiction can be challenged at any time. But when you're in equity, and because of the Judicature Acts and the Civil Code and everything else, when you're in there, you're presumed to have consented and or been aware of your contracts. It's called ignorance of the law. Well, let me tell you, recently I've been enjoying going into a couple of court situations against attorneys where I've constituted and established my own court of record proceeding in the common law. And when the attorney starts, saying, well, he can't do that, whatever, first thing I say to the judge is, well, I'm afraid that counsel is not to be precluded from the fact that ignorance of the law is no excuse. And believe me, they are very ignorant of this. But the judges are not at a certain point. What does this all mean? We got to be educated, because I can give you a nice 45-minute dissertation about this, but believe me, a lot of detail. But it can be relatively simplified. And establishing our law and our courts of record in the Republic is paramount. Okay, so Jubilee. Okay, that brings up a good point. Let's go back to my original point of the Articles of Confederation, the Constitution. Part of the argument is the Constitution is flawed. Maybe it is, maybe it isn't. It certainly has been used as a two-edged sword. Okay, because Article 6 starts by saying, henceforward all debts and engagements previously valid against the Confederation shall remain valid against the United States. Debts and engagements, that's the point of the Constitution, accepting the debts now valid against the United States. So, but there's, I lost my train of thought there. Yeah, well, no, yeah, no, the argument that the Constitution is invalid or is flawed. What I meant to say is it's a two-edged sword. That is the hook, that debt engagement, as I described earlier, that takes us back to the Crown, Vatican, and all the rest of it. The key is also that the United States, the federal entity, was both constitutor and the fiduciary that was established to hold in trust for the sovereign as the heir and the beneficiary of all those things that were established at that time, including our sovereign capacity to stand on the land and be free. There's one very key thing. In trust law, when the trustee derogates or becomes derelict in their duty or abrogates that fiduciary responsibility, they abandon the trust. All we have to do is claim the corpus of the trust by their dereliction of duty. They, meaning the United States. Everything we're talking about can be encapsulated in one thing. The federal government abandoned the trust. All we have to do is claim it, which essentially is what we're doing. So we don't need a jubilee. What we need is Congress, the National Congress, to put a bill together to address all of those components that we consider flaws in the Constitution, and or to bring forward at present time those things that we want to be brought forward. You know, equality for women, equality for blacks, Indians, et cetera, et cetera. All of those good things that we know are required now, and we don't have to play the games that have been played for 140 years. Bring those forward and make them part of the Constitution, remove the parts that we don't, and settle. How do we settle? By the act of both dereliction of duty, abrogation of the trust, abandonment of the trust, and the fact that we have paid the debt. Okay? By evidence of what's in the public record of the last 100 years and all the fraud and the complete, stealing of the wealth of the people and the land that has gone on for foreign principles. That we have paid the debt. They've abandoned the trust. We reclaim the corpus, and we declare that we have that the debt is settled irrevocably, uncontestably, unless they can bring forward proof of claim that there's a valid basis for continuing the debt. If we pass that in Congress as an article of amendment, I would propose that Debbie, what you said is that the first 10 articles is where we're starting from, then let's make this the new 11. Okay, pass this, clean it up, put it out to all the state republics to ratify. Once it's ratified, it is presented to those principals in DC, in London, and Vatican. Demand them to show up in our Supreme Court with evidence, just as President Turner has done. Bring your evidence. None of this gossip or bullshit of undermining and all the rest of it. You bring the evidence that you have authority to do what you say you have authority to do, and they don't. And if they don't bring it forward in our judicial body, then it's settled. Okay, and that's all. Now, what I've just described is how it was put together, and I don't want to. I mean, this is enough because we have some business to do for the rest of the afternoon. But I wanted this, and I'm glad that we reported this, to be a framework for you to understand what has been done. This is just a framework. The detail is quite extensive, but in the simple building blocks that I've outlined, this is how it's been structured. Okay, and we have the remedy because of the fraud, the lack of disclosure, and all the rest that we know, and going back to the Declaration of Independence, the description of the ongoing train of abuses, and et cetera, et cetera, et cetera. Okay, it's all very clear. So we have constituted a legislative body at the national level. The proper structure and relationship is for us to propose our representatives to give them the mandate to put a bill like that and bring it to the National Congress. That's all we really need to do.